Hi, I'm attorney Mark Rosenfeld, Mr. DUI LA, and I want to talk to you for a minute about some of my past experience with DUI cases. So I want to talk to you about Sherri's case. Sherri is another client where we successfully settled the case on the eve of trial. We were prepared for a jury trial, but because we were prepared, we were able to negotiate a settlement at the last minute. Sherri was driving home from work. She worked in Burbank, lived in West Los Angeles, and as she was coming over the hill, she was involved in a couple of minor accidents. One of the accidents, she didn't realize that there was an accident, and the second accident, she actually stopped and exchanged information. She was then taken home because her car was totaled, and the LAPD actually came to her house to do a DUI investigation. And they conducted an investigation in her front yard, asking her about where she was coming from, where she was going, what she ate and drank, and she denied having anything to drink at the house, but we had testimony or statements in the field that she was impaired, and that's what caused the accidents. The case was filed, originally charged as a felony DUI with injury and a hit and run. After talking to the district attorney's office, explaining the situation and discussing Sherri's position, not knowing about the extent of the damage on the first one, finding out what the real injuries were and how they were not severe enough to be filed as a felony, we were able to get the district attorney to reject the case. The case was handed from the district attorney to the city attorney. So Sherri's case was originally an arrest for felony DUI with injury and hit and run. After discussing and negotiating with the district attorney's office, we were able to convince them that felony charges for DUI and hit and run were not appropriate, and they agreed. They rejected the case, and the case was transferred to the city attorney, and it was filed as a misdemeanor. Through our investigation and research, we were able to show the city attorney's office that there were severe issues with them being able to prove impairment at the time of driving. Because we were able to show the city attorney's office that there had been drinking at the house after the accident, the city attorney then agreed that they would not be able to prove beyond a reasonable doubt that Sherri was impaired for purposes of driving at the time of the accidents. However, they chose to go forward with the hit and run allegation, which is a crime of moral turpitude. So we continued to push, and we got to the point of almost starting trial with a jury waiting outside, and it was at that point where we were able to negotiate not only with the city attorney, but with the judge that was assigned to the case for trial, and work out what is called a civil compromise, where we agreed not to admit fault, but to compensate anybody who was injured as a result of this accident, and after the person would be compensated in full, the charges would be dismissed. So in Sherri's case, what started out as 2 hit and runs, felony DUI with injury, ended up at the end of the day with a civil compromise where some money was paid and the case was dismissed in the interest of justice, facing state prison to no conviction at all. DUI cases can be won, but they need an attorney who's willing to stand up and fight for your rights. I'm DUI Defense Attorney Mark Rosenfeld. If you want to talk to me about your case, give me a call. You can reach me directly at 800-9700 DUI. That's 800-970-0384.